This is an appeal in the matter of the King on application of Castellucci and gender recognition claim.
My ladies, my lords, I'm here on behalf of the appellant with Ms. Bellers, Sir James Eady, King's Counsel, and Mr. Blackmore are here for the Minister. Could I please check the court has the bundles? I hope you have a core and supplementary documents bundle and a 2-volume authorities bundle.
We do, thank you.
This is an appeal against the High Court's decision to dismiss the appellant's claim for judicial review and appeal under Section 8 of the Gender Recognition Act. We appeal on 2 grounds. 1, statutory interpretation, and 2, Article 14 ECHR. By way of introduction, Ryan is a national of the United States. Their birth, and with it their gender, is registered in the state of California. Under the law of California, gender means male, female, or non-binary. Ryan's gender is registered in California as non-binary, and they have no other gender designation in the United States. Ryan's gender isn't registered in the UK. Their only registered gender is their Californian non-binary registration. They've been diagnosed with gender dysphoria, and following surgery and hormone therapy, their body aligns with their registered gender. In the UK, gender means something different to gender under Californian law. It means male or female. The statutory interpretation question is whether the Gender Recognition Act applies only the domestic law meaning of gender, or whether it also provides for the recognition of gender as defined by certain foreign laws, such as the law of California. The Gender Recognition Act makes provision for people to change their gender in the UK. That domestic process uses the domestic meaning of gender and only provides for changes from male to female or female to male. But the Act also makes provision for the recognition of changes of gender that have already taken place in an approved foreign country or territory. And for that purpose, Section 1, subsection 2b of the Act defines acquired gender to mean the gender to which the person has changed under the foreign law. We say that the Act thereby contains a renvoi to foreign law. We accept that non-binary gender is alien to domestic law in the sense that it can't be obtained under domestic law. And in one sense, it might seem paradoxical for UK law to recognise an alien foreign law status. But domestic law can, and in certain circumstances does, recognise alien foreign law statuses that can't be obtained domestically. For example, polygamous marriages and civil partnerships between brothers and sisters. Parliament may not have had foreign non-binary gender status in mind when enacting the Gender Recognition Act, but what it did was to enact a structure for the recognition of foreign acquired genders that endures across time and is capable of dealing with new cases that may not have been contemplated by the legislator. The structure that Parliament enacted was to define acquired foreign gender by reference to foreign law, whatever that foreign law might be, providing that it's the law of a prescribed territory. Now, Parliament could have placed limits on what foreign acquired gender will be recognised in the UK. For example, changing gender in the UK requires medical evidence of psychological or surgical alignment with the acquired gender. Parliament could have provided that only foreign changes of gender of that kind would be recognised. But Parliament didn't impose limits of that kind, Instead, the control mechanism is that foreign law statuses are only recognised if the territory is prescribed by statutory instrument in an approved list. If a country is on that list, then changes of gender under the law of that country are accepted without qualification. If its laws are considered inappropriate, it can be removed from the list. That's the case on statutory interpretation that I propose to develop. Article 14 then, if on its ordinary reading the Act excludes the recognition of foreign acquired genders other than male and female, then this issue arises. Having chosen to confer a benefit in the form of a gender recognition certificate on one person who couldn't change gender under UK processes, for example, a person who's obtained male gender under Californian self-ID law, what's the justification for denying that benefit to another person who couldn't change gender under UK processes? Here, a person who obtained non-binary gender under Californian law. And we say, or I will say, that the difference in treatment isn't justified in circumstances where giving the certificate in the latter case no more undermines the domestic system than the former case. Could I then start with the proper interpretation of the Act?
Yes.
And I propose to deal with 4 topics. First, the wording of the Act. Second, the consequences of our interpretation of the Act. Third, the purpose of the foreign recognition route. And fourth, the application of that interpretation to the appellant's case. So topic 1, the wording of the Act. Could I please ask the Court to turn up the Act, which is at tab 1 of the authorities bundle.
Right, tab.
Tab 1, page 4. Subsection 1 identifies who can apply for a gender recognition certificate. And in my submission, gender is used in 4 different contexts within subsection 1. First, 1.1a refers to the gender in which a person is currently living in the UK. That's context 1. Second, in connection with 1.1a, the opening words, a person of either gender, is referring to the individual's current gender under UK law. That is, the gender registered on the individual's birth certificate in the UK. Third, 1.1b refers to the gender that's been acquired under the law of a foreign territory or country. Fourth, in connection with 1.1b, the words a person of either gender is referring to the individual's previous gender under the law of the foreign territory, before the new gender was assigned under that law. So in my submission, the word gender is being used in different contexts, and in those different contexts, it carries different meanings. Words aren't simply building blocks that are put together like Lego. They have shades of meaning, which becomes determinate when used in specific contexts for specific purposes. If I could ask at this point the Court please turn forward to page 41. Section 25, interpretation. This defines the acquired gender by reference to section 1, subsection 2. I'll turn to that in a moment, if I may. What I observe at this point is that there's no definition of gender in the Act. And one can contrast that with the Equality Act, which we've got at Authority tab 17. And one sees at page 249, section 11A, sex means man or woman. And then page 251, section 212, subsection 1, man means a male, and overleaf, woman means a female. So returning to the Gender Recognition Act, Parliament could have limited the meaning of gender in the same way, but didn't do so. So having identified the definition of acquired gender, could I ask the Court please to turn back to page 4. Section 1, subsection 2, 2A concerns changes of gender in the UK. The acquired gender is the gender in which the person is living. 2B concerns changes of gender that have already taken place under a foreign law. The acquired gender is defined by the foreign law. Could I then please say a little more about the opening words of subsection 1, which describe the prior gender using binary language, a person of either gender. A person born in the UK will always have a prior binary gender because UK law requires every person born in the UK to be registered as male or female, as my Lord noted in the case of TT. A person born abroad will probably have a prior binary gender under the foreign law, as was the case for the appellants. But that won't always be the case. For example, German law allows a person to be registered at birth as having a diverse gender, in effect intersex gender. If I could just give the Court a reference to that, it's in Ms. Thompson's witness statement, supplementary bundle, page 50, paragraph 47b. Now suppose that a German national who was assigned diverse gender at birth and later acquires male or female gender under German law. Would the GRA permit recognition of that acquired female gender even though the words of either gender would be inapt to describe the previous intersex gender? Now, the Court doesn't need to determine that point because, as I say, the appellant has a prior binary gender. But my submission is that such a foreign change of gender probably would fall within the scope of subsection 1, because in my submission the word either in either gender isn't intended to be a limiting condition.
What do you say the word either means?
It's a description. It's intended to describe the prior gender. And as I say, in all the UK cases and in the vast majority of foreign cases, the word either is apt to describe that. But in my submission, it is intended as a description rather than a limiting
So it doesn't exclude someone who might have been registered in Germany
as
It's
intersex.
more neutral.
Do you say it's intended to be all-embracing and inclusive? Otherwise, you might say, well, certain rights only flow to a person of one gender, but this is saying it doesn't matter which gender you are earlier, a person of either gender can make this kind of application.
If I may respectfully say so, that's a better way of putting it.
Well, no, I mean,
Inclusive, it's an inclusive, in my submission, it's an
Yeah.
inclusive description,
rather than limiting one.
rather than a limiting one.
Right.
And so my overarching submission on section 1 is that changes of gender in the UK follow the UK binary approach to gender. The changes from the registered gender, which is male or female, to the other gender that exists under UK law. Changes of gender that have taken place abroad follow the foreign law approach to gender. However, that's defined by the foreign law. Now, at paragraph 116 of its judgment, the High Court didn't consider it plausible that Parliament had used the same word, gender, to mean different things in the same subsection of an act. Now, I accept that generally speaking, the use of the same word in the same subsection may well be the determining contextual feature that gives the word its meaning. But that needn't necessarily be the case. And could I please give the court 2 examples of that? The first is the case which is at tab 29. This was a claim for judicial review by the Secretary of State of a decision of the Immigration Appeal Tribunal. And one of the issues in the case was the proper interpretation of section 22, subsection 1 of the Immigration Act 1971. If I could show the court the statutory provision, it's at page 443. And at paragraph 9, could I ask the court please to note the wording of subsection 22(1)(a). Now, counsel for the Immigration Appeal Tribunal argued that the word appeal had a single meaning in that subsection, so that an appeal from an adjudicator and the appeal both referred to the appeal to the Immigration Appeal Tribunal, with the consequence that the Immigration Appeal Tribunal could remit or delegate the appeal against an adjudicator's decision to another adjudicator. If I could just show the court how that point's described in the judgment, if we could look at page 446. If the court would please read paragraph 26. And the way in which the judge resolved that difficulty is set out at page 448. If the court would please read paragraph 35. So that's my first example. The second example is at tab 36. This case concerned Julian Assange's challenge to a European arrest warrant, and the issue was whether the words judicial authority covered an authority that wasn't a judge or a court.
Which tab did you say?
It's tab 36.
36, thank you.
And the majority concluded that the expression, as used in the Extradition Act, had the same meaning as in Article 6 of the relevant international instrument, the framework decision. So can I show the court, please, the text of the framework decision? This is page 683. At paragraph 57, Lord Phillips set out the text of Article 6. If I could ask the court, please, to look at Article 6, paragraphs 1 and 2. Now, the court concluded that in Article 6, paragraph 2, the executing judicial authority meant a judge or court. What did that say about the meaning of judicial authority in Article 6, paragraph 1? Could I ask the court, please, to look at page 707? And if you would please read paragraph 150 of Lord Dyson's judgment. And then paragraph 75 of Lord Phillips' judgment is at page 688. And so we say that a word can mean different things in different contexts, even within the same subsection of an act. And my submission is that gender, in the context of the domestic legal framework, may mean something different from gender in the context of a foreign legal framework. Could I then please show you the criteria for granting a certificate? We turn back to tab 1, page 4. Section 1, subsection 3, applications are to be determined by the panel. Overleaf, section 2, subsection 1. In a domestic case, so a 11A case, the panel has to be satisfied that A, the person has gender dysphoria, B, they've lived in the acquired gender for 2 years, C, they intend to continue to live in the acquired gender until death, and D, satisfy the evidential requirements of section 3. So section 3, the evidential requirements, on page 6. Section 3, subsection 1, 2 medical reports are required to satisfy the gender dysphoria condition. Section 3, subsection 4, a statutory declaration is required to satisfy the 2 years criterion and the intention criterion. And when determining a 11A application, the panel scrutinises the medical evidence. If I could show you, please, page 47. This is Schedule 1 to the Act, paragraph 4, subparagraph 2. A panel that determines a 11A application must include both a medical and a legal member. In relation to 11A cases, I think I should probably show the court also the alternative route for granting a certificate. Nothing turns on it, but for completeness. This is in section 3, capital A, which is at page 9. If the person has been living in the acquired gender for 6 years, then they're entitled to rely on surgical treatment to modify sexual characteristics without needing to show gender dysphoria. One sees that at subsection 5. And they then only require 1 rather than 2 medical reports. That's section 3, capital B, subsection 2. So that's the domestic route. By contrast, in a 11B case, a foreign case, the panel is only asking whether a change of gender has occurred as a matter of foreign law. And if we could turn back, please, to page 5. Section 2, subsection 2. The panel needs to be satisfied that A, the country or territory is an approved country or territory, and B, that the evidential requirements are satisfied. The evidential requirements again are set out at section 3. Section 3, subsection 5, the evidential requirement is to show that the change of gender occurred under the law of that country or territory. And then as to the constitution of the panel, if we could turn back, please, to page 48. Schedule 1, paragraph 5, the panel can be constituted of a single legal member, as it was in this case. Page 48, paragraph 5. Now, in both 11A and 11B cases, there are then special provisions if the individual is married, but that didn't arise here and doesn't, in my submission, cast light on the point in issue. The effect of this framework, in my submission, is that it provides for the recognition of a foreign gender change that couldn't be granted in the UK. For example, a person may have acquired the foreign gender when they were under 18. To show you that point, could we look back, please, to section 1, subsection 1, on page 4. The opening words: although the application for recognition of the foreign gender change can only be made once the applicant is 18, the Act allows for the recognition of foreign gender changes that occurred when the applicant was a child, if that's what the foreign law allows. And also, by way of example, in a foreign case, the individual might not have gender dysphoria. The individual might never have lived in the other gender. The individual might not have committed to living in that gender until death. The change could, as a matter of theory, looking at the Act, the foreign change could be based solely on a desire to be recognised as another gender, for example, to take advantage of preferential pension rules for women.
Mr. Butler, can I just ask you this? Are there jurisdictions elsewhere in the world where self-identification in a new gender suffices to be granted the change in gender.
Yes, my lord. And examples of that are set out in Ms Thompson's witness statement.
Yes.
And indeed, although the appellant has a diagnosis of gender dysphoria and has had gender-affirming surgery, California, in fact, allows self-identification.
Right. And so your submission would be, would it, that in such a case, if those were the facts, the UK would be required under its own act to recognise that change of gender, even though quite clearly under domestic law it would not be a permissible route to change of gender.
That's my submission.
Right.
So long as the foreign law has been approved in the sense that it's included in the schedule to the approved territory's order.
Is that in dispute, as far as you know?
I sense it may be.
All right.
And I'm going to address what I anticipate will be the point taken against me in a little while, if I may. The only questions in my submission for the panel in a 11B case are whether the foreign territory is listed in the territory's order and whether the gender change occurred in accordance with that foreign law. Now, for completeness, can I please show the court page 37? Section 21, subsection 1, a person's gender isn't to be regarded as having changed by reason only that it's changed under the law of the country or territory outside the UK. You have to go through the foreign process under the Act. And the control mechanism, as I've put it, is the provision that I showed you at section 2, subsection 2A. The panel has to be satisfied that the change occurred under the law of an approved country or territory. Section 2, subsection 4 defines an approved country or territory to mean a country or territory prescribed by order. And then page 40, section 24 sets out the procedure for making such an order. Page 40, section 24, subsection 2, the order may be made by statutory instrument. Subsection 3, the order must be affirmed by affirmative resolution. Now, Parliament could have imposed outer limits on the recognition of foreign genders, either by prescribing limits in the Act or by placing limits on the Secretary of State's order-making power. For example, by providing that the foreign change of gender must be based on gender dysphoria or gender-affirming surgery, or, for example, by limiting the change to male or female gender. Instead, the Act leaves the assessment of the adequacy of foreign law entirely to the Secretary of State and the affirmative resolution procedure. Now, if I might at this stage anticipate the point that may be taken against me, which is that 9 months after the Act came into force, the first territory's order was made. And the Constitutional Affairs Department of the government stated in the explanatory memorandum to that order that the intention of the Act was that foreign laws would only be recognised if they were as rigorous, as it was put, as the UK system. I accept that in principle, a nearly contemporaneous statutory instrument can cast light on the meaning of an Act, and I accept that the explanatory memorandum to a statutory instrument can in principle cast some light. but it can't change the meaning of the words of the Act. And in my submission, the Act doesn't contain any such limitation. Such a limitation can't be read into the Act by virtue of an explanatory memorandum to a later statutory instrument. And one can test that in this way. In my submission, it couldn't be said that the government would act ultra vires if it made an approved territories order that included countries allowing self-identification. And nor could it be said that it would stop being lawful to grant certificates if a listed country changed its internal law to permit self-identification. I don't know whether it's going to be said that the moment that California changed its process to one of self-identification, it ceased to be lawful to grant certificates for male or female changes of gender under the law of California under the 2011 order. Could I please then show the court the 2011 approved countries order? This is at tab 3, the authorities. And this was the order that was in force when the appellant applied for a gender recognition certificate. Paragraph 2, the approved countries or territories are listed in the schedule. The schedule begins at page 96. The state of California is included at page 97. Now, in the witness statement that was filed on behalf of the Minister, Ms. Thompson's witness statement, she explains which of this list recognise non-binary gender. Just for I don't propose to turn the witness statement up unless you want me to, but for your reference, it's supplementary bundle tab 3, page 49. And what Ms. Thompson explains is that of this list, the Australian territories, the Canadian provinces, Denmark, Iceland, Malta, the Netherlands, New Zealand, Spain, and many of the United States provide for non-binary gender.
Sorry, what was the reference to?
The reference is supplementary bundle tab 3, page 49.
Thank you.
And Ms. Thompson, as I've already indicated, also explains that Germany, which is also in this schedule, recognises diverse or intersex gender. So if my lord is looking at the witness statement, page 49,
yes.
There's a list of countries of those that are in the 2011 order. A, Denmark is, B, Iceland is, C, Malta is, D, Spain, 47A, Austria, B, Germany, C, the Netherlands. And then on page 51, those in the list are B, Australia, C, Canada, I, New Zealand, and then 52K, USA.
Yeah. Thank you.
Could I please illustrate this point by showing you Malta's gender recognition law, which you've got in the authorities bundle at tab 58. So towards the bottom of that page, within section 2, non-binary gender is defined as all gender identities other than male and female. Over leaf, section 4, subsection 1, sets out the right of Maltese citizens to change their gender, including to non-binary gender. Over leaf, top of the page, subsections 2 and 3, this is another example to answer my Lord Justice Singh's question, another example of self-identification. And then page 1458, one can note that at section 7, this empowers a court to change the gender of a child under 16 on the application of a person with parental responsibility. And then over leaf, so page 1459, section 9, subsection 1, sets out a provision that has some resemblance to our interpretation of the foreign recognition route in the UK. It provides for the recognition of foreign gender statuses. And what we say naturally follows from the Gender Recognition Act is expressly stated at page 1460, subsection 4, which provides for the recognition of foreign gender markers even if those gender markers can't be given under Maltese law. So that's just by way of illustration of the law of one of the territories that's included in the 2011 order. The 2011 order was replaced by the 2024 order. That's at tab 4 of the authorities.
And although it must be assumed that the Secretary of State and Parliament had its eyes open to the fact that a number of the states who are on the list have a broader definition of gender than the UK law, and although those countries have been put on this, nothing in the statutory instrument says we recognise gender acquired under the law of California, except non-binary or whatever the difference might be. Just purely, if it's that jurisdiction, it's in.
It's done on a jurisdictional basis. The question arises whether the order-making power would permit the Secretary of State to list a territory, but only certain aspects of the law of that territory,
yes, so
as to limit changes of gender under Maltese law, but only if there was a diagnosis of gender dysphoria, or only if the person was over 18, or
yes,
only if it was a binary gender. It may be, I certainly don't suggest that it would be unlawful for the Secretary of State to do that. My point is simply that in the 2011 order, which is what we're concerned with, that didn't happen.
Sorry, we were going to the 2011.
So I've turned to the 2024 order, which is at tab 4 of the authorities. And if we could look straight to the schedule at page 99, we can see that all of the countries that I referred to in the 2011 order have now been removed, except Germany. A number of countries have been added, including India, and I would just note that Ms. Thompson, in her witness statement notes that India recognises third gender in addition to male and female. The reference is supplementary bundle, page 51, paragraph G. And if we look at the top of page, still within the 2024 order, we could look at the top of page 100, we can see that the state of California has been removed.
There's a helpful summary lower down in the page of those that are in and those that are out.
Yes. Yes. But the removal of the state of California doesn't affect this case because of the saving provision at the top of page 99, Article 4 of the order.
And looking at the, just slightly earlier in the bundle, just behind the tab, there's the explanatory memorandum to the 2024 order, page 101B, under the heading Policy Background,
Yes.
7.4.
Yes.
This statutory instrument will remove countries and territories where there's clear indication that they no longer have a system at least as rigorous as the UK, and add countries that. But it doesn't say anything about the categories of gender that are recognised. It's the rigorous nature of the system.
Yes.
Full stop.
And my answer to my Lord Justice Singh's point earlier, in anticipation of this point, was that even if one could read the explanatory memorandum as an indication that there wasn't an intention to recognise foreign changes of gender, unless, for example, they were based on a diagnosis of gender dysphoria. The explanatory memorandum doesn't say that in terms, it simply uses the loose term rigorous. But in any event, in my submission, the explanatory memorandum to the latest statutory instrument simply can't change the meaning of the order-making power, which doesn't contain any limitations of that kind. Which is why I say in my submission, it would not be ultra vires to make an order that provides for the recognition of a law that allows self-identification. Still less would it become unlawful to grant a gender certificate in a foreign case where the law of the relevant territory is included in the order, but since the order was made, has introduced self-identification into its law. So,
Forgive me, Mr. Butler. In any event, if I've understood you correctly, the UK has decided in the 2024 order to include India, presumably with its eyes open, that India has in its law the possibility of a third gender.
yes, because it's expressly stated in the department's witness statement in these proceedings which predated the 2024 order.
And is it your understanding that the government's position would be, if it were to be tested in court, and there was a citizen of India who was in the same material position as this appellant, if they brought a case like the present one, is it your understanding the government would submit in that case also that the legal consequences are exactly the same as they were held by the Divisional Court to be in this case?
That's certainly my understanding. Because, so the government argues, gender within the Gender Recognition Act can only mean male or female, even in respect of the meaning of gender under foreign law. That's the government's case. My case is foreign law means foreign law. So that was my first topic, the wording of the Act. Could I then please turn to my second topic, the consequences of recognising foreign non-binary gender, if my reading of the Act is correct. Could I begin by looking at what the Act provides if the panel finds that there's been a change of gender under the law of a recognised foreign state. If we could turn back, please, to page 5. Section 2, subsection 2, this is what I would call step 1. If the criteria are satisfied, the panel must grant the application. And then step 2, page 17, section 4, subsection 1, if the panel grants the application, it must issue a certificate. Page 17, section 4, subsection 1, what I would characterise as step 2. Then step 3, section 10 and schedule 3 provide for the modification of the individual's UK birth register entry, if they have one, and for registration in all cases in the gender recognition register. And then step 4, page 31, section 9, subsection 1, where a full certificate is issued, the person's gender becomes, for all purposes, the acquired gender. Now, if I might say a little bit more about section 9, as I say, subsection 1, the individual's gender becomes the acquired gender. And as I showed you, section 25 defines acquired gender by reference to section 1, subsection 2. And as I showed you in a foreign recognition case, section 1, subsection 2b defines acquired gender as the gender under the law of the approved territory. All of that carries into section 9, subsection 1. In my submission, the words in brackets don't cut down the meaning of acquired gender. The brackets contain two provisos. If the acquired gender is male, the person's sex becomes that of a man. If the acquired gender is female, the person's sex becomes that of a woman. Neither of those provisos apply in our case. The brackets in my submission simply don't apply if the acquired gender isn't male or female.
It doesn't say, as it might have said, so that, comma, for example, comma.
It doesn't use the words, for example. But in my submission, the words in brackets are illustrative. Otherwise, Parliament would have been cutting down the definition of acquired gender by a most indirect route in circumstances where acquired gender has an express statutory definition set out in section 25. What then are the consequences of a gender recognition certificate? Well, subsection 9.1 provides that the person's gender becomes the acquired gender for all purposes, but that's qualified by subsection 3, which provides that this is subject to contrary provision in the Gender Recognition Act or in any other enactment or subordinate legislation. There are then a series of provisions in the Act addressing the consequences of acquired gender in certain situations. For example, page 35, section 12 the acquired gender doesn't affect the person's status as the mother or father of the child. That was the question of construction that was considered in the McConnell case. And then there are a series of other examples. I don't propose to go through them all unless you'll desist. In light of section 9, can I address the court on what we say would be the consequences of a non-binary gender recognition certificate? The Minister says that a non-binary certificate would create two sets of problems. First, the Minister says that it would threaten the coherence of the domestic legal order, which is based on male and female gender. And second, and relatedly, it would compel reform which would be burdensome and costly. And so the Minister says that our interpretation of the Act would result in absurdity. And this is also the Minister's central argument on justification under Article 14 ECHR. Now, we say that our interpretation wouldn't have any of the legal consequences that the Minister contends, and that the practical consequences of a non-binary certificate would be modest.
Would you include, perhaps you could include and expand in relation to the criminal law?
I'm so sorry, my lady.
Could you expand that argument in relation and apply it in relation to the criminal law?
Well, the criminal law is already addressed to an extent at page 37, section 20, in relation to gender-specific offences. The submission.
But the difficulty would arise if you've got an enactment which, such as female genital mutilation, for example, which specifies by the word female the ambit of the offence, and which would not be covered in the context we're talking about here.
I'm going to come on and deal with this head on, but can I give a short answer now, which is that many acts of Parliament are predicated on binary gender, either male or female. If one has an individual who has a foreign non-binary registration, or on this hypothesis, a domestic non-binary gender certificate, it will be a question of the proper interpretation of the act in question as to how that person should fit into that act. Now, clearly an act which is based entirely on male or female gender cannot incorporate the concept of non-binary gender. And in those circumstances, the likely outcome is that, as a matter of interpretation, one will have to work out which of the male or female gender the person with a non-binary certificate has to fit into. Now that, in many cases, the answer may be the old Corbett test, which is to take a chromosomal approach to whether a person fits into the male or female gender. But it's always, in my submission, a question of the proper interpretation of the act in question.
Well, that's one way of looking at it. Another way of looking at it is that the proper interpretation of the Gender Recognition Act is not to view it as being apart from the rest of the statute book, but that it should be read harmoniously with and in the context of the rest of the statute book. And I think the Secretary of State's submission is that it's their interpretation which has that better fit.
If we were dealing with an act which referred to the concept of gender in unvarnished terms, then I would entirely accept that one would have to read that notion of gender in light of the approach to gender across the board in UK statutes. But what we've got here is a distinct carve-out in the Act, which, as I said in my submission, contains a renvoi to foreign law. Now, Could I try and address both my Lord's question and my Lady's question now in the structure that I was proposing, which is, I was going to make 3 points. Point 1, what is the effect of recognising alien foreign law statuses on the coherence of domestic legal order? This is going to, I hope, provide an answer to my Lord Justice Singh's point. And I propose to give some examples, including the recognition of polygamous marriages. My second point, how would legislation that's based on male and female gender apply to a person with a non-binary certificate? And I hope that will provide an answer to an extent to my Lady's question. And then there's an additional point, my point 3, which is what, if any, public law duties would be owed to a person with a non-binary certificate? So point 1, the impact on the domestic legal order, on harmony. We say that English law can and does recognise statuses acquired under foreign law, even if those statuses can't be obtained under English law, and indeed, even if those statuses are anathema to the values underpinning English law. And it does so without threatening the coherence of the domestic approach. And I propose to advance 5 examples on this. The first example is polygamous marriage. Now, polygamous marriages have long been regarded as anathema to UK values. And to make that point, could I ask the court please to turn up tab 19 of the authorities. The case of Hyde and Hyde. The case concerned an application for divorce in respect of a polygamous marriage contracted in Salt Lake City, as it happens by Brigham Young. The question was whether this was a marriage within the meaning of the Matrimonial Causes Act. And Lord Penzance held that it wasn't. And if we could look, please, as to why that was, at page 260. There's a passage beginning about 6 lines down, but I expressed at the hearing. If I could ask the court, please, to read the rest of that page and the rest of the following page. It won't require very close attention, but just to get an impression. And then, in addition, a much shorter passage at page 263, if the court might read the first 8 lines on that page. Now, although such marriages were, in Lord Penzance's words, heretical and revolting to UK law, the courts were willing to recognise polygamous marriages for other purposes, and then Parliament amended the Matrimonial Causes Act to recognise foreign polygamous marriages for those not domiciled in the UK. If I might just ask the court to turn up tab 9. Page 109, section 47, subsection 1 of the Matrimonial Causes Act 1973, a court isn't precluded from granting matrimonial relief or making declarations concerning the validity of a marriage just because it's polygamous.
Is there any distinction to be drawn in that context of just noting without reading it out what's on the bottom of page 262 about, as it were, the consequences of taking a different view from, again, coming back to the criminal context? It's about visiting consequences of the nature of the relationship voluntarily acquired in a different jurisdiction.
Yes.
Upon the parties in those circumstances. Whereas here the consequence may be a completely different one, unless the criminal law were to be interpreted subject to the issues that are in play here.
I'm going to...
It may involve, in other words, somebody escaping criminal responsibility or not having the protection of the criminal law.
In my submission, it won't have that consequence. I'm going to come on and deal with the relationship between a non-binary certificate and statutes in a moment, if I may. At this stage, I'm just looking conceptually yes, at the possibility of having a repugnant alien foreign status being recognised by English law. So I've shown the court page 109, section 47 of the Matrimonial Causes Act. Now, in my submission, in recognising foreign polygamous marriages for that limited purpose, Parliament was in no way approving of them or suggesting that the law governing marriages in England and Wales should be amended to permit such heretical marriages or in any way undermining the law relating to bigamy. It was simply recognising the existence of a status obtained under foreign law. That's the first example. The second example concerns civil partnerships, which are governed by the Civil Partnership Act, which is at tab 16. And if we could begin, please, at page 217, one can see section 3, eligibility, identifies the essential characteristics of civil partnerships in English law. And those include section 3, subsection 1D, that the civil partners aren't within prohibited degrees of relationship. So accordingly, a partnership between siblings would be as heretical to English civil partnership law as it is to matrimonial law. At the same time, the Act provides for the recognition of civil partnerships contracted under foreign laws. If we could look, please, at page 220. Section 212, subsection 1, provides two alternative routes to foreign recognition. The relationship must either be of the kind specified by the Act, or it must meet the general conditions prescribed by the Act. And I'd ask the court please to note that at subsection 2, the relevant law is the foreign law just as it is under Section 1, subsection 2b of the Gender Recognition Act. And then if we could look, please, at page 223, Section 213 provides that the specified relationships are set out in Schedule 20 to the Act, and overleaf, page 224, subsections 5 and 6 empower the Secretary of State to add or subtract a specified relationship from Schedule 20. Schedule 20 begins at page 238. And the list includes foreign statuses that are antithetical to English notions of civil partnership. For example, page 240 includes, at the bottom of the page, Californian domestic partnerships and marriages. It thereby covers partnerships between a man or woman and a non-binary person, or between two non-binary people. And the penultimate entry on that page lists reciprocal beneficiary relationships in Hawaii. Those relationships are only available to persons who fall within the prohibited degrees of relationship. And the example given in the Hawaiian statute book, on the face of the statute book, is a reciprocal relationship between widowed mother and unmarried son. Totally unlike the UK conception of civil partnership. The only limitations on the recognition of these alien statuses is set out at page 229. Section 215, subsection 1, the parties must have had capacity to enter into the relationship according to the foreign law, and the foreign law requirements for validity need to have been satisfied. I'm so sorry, there's a page missing from the extract of the Act. We're missing section 217. If I could please hand up a copy of that.
Thank you.
This sets out the other limiting condition, but it only applies if at least one of the parties to the partnership was domiciled in the UK at the time the partnership was registered abroad. If that's the case, if one of the parties was domiciled in the UK, then partnerships are excluded if either person was under 18 or if the relationship was within the degrees of relationship that are prohibited in the UK. But if neither party was domiciled in the UK, then it's no impediment that one of the parties was a child, or that the parties were within prohibited degrees of relationship. And then finally, page 236, section 218, the partnership isn't to be recognised if recognising the foreign law's approach to capacity would be manifestly contrary to public policy.
So how does it come to be determined whether it is or it isn't manifestly contrary to public policy? So all your submissions were going well to that moment, but then there's this break clause.
Well, in construing the break clause, in my submission, one has to read it with section 217. And in 217, Parliament is contemplating the possibility of a relationship under foreign law within prohibited degrees of relationship.
So if, for example, someone was within the prohibited degrees of relationship, you would say because that's expressly contemplated within section 217, it can't be a characteristic which would render it manifestly contrary to public policy under section 218. Otherwise, they simply wouldn't have 217.
Well, not only that, one wouldn't have 217, but one also wouldn't include within Schedule 20 a relationship which requires that the partners are within prohibited degrees of relationship.
Yes, I mean, I think, speaking only for myself, obviously, I mean, I find it quite difficult to unpick this without knowing a little more about, for example, if you referred to the reciprocal beneficiary relationship in Hawaii. And there have been occasions in relation to the law in this jurisdiction where it's been pointed out that the financial benefits, for example, that accrue to civil partners should be available to brother and sister who have lived domestically for a very long time, but without in any way suggesting that that would sanction what would otherwise be described as a prohibited sexual relationship. So, I mean, I think it rather depends, and we don't have that information for the purposes of this submission.
No, what you've got is you've got the Hawaiian summary of the legislation at tab 59. But my lady, I entirely accept that the Hawaiian concept of reciprocal relationship it is not a sexual relationship. Of course, it's not a sexual relationship in any way. It's entirely a relationship based on practical and financial considerations. But the submission that I'm making is that through the Civil Partnership Act, Parliament is willing to recognise such foreign statuses, even though they are antithetical to English concepts of civil partnership, which are based entirely on sexual relationships. Now, in my submission, as with polygamous marriages, Parliament wasn't necessarily suggesting that the kinds of registered relationships permitted in California and Hawaii were a good thing. To the contrary, it prohibits registration of such relationships under English law. Instead, in my submission, Parliament is willing to recognise and give effect to statuses that can only be formed under certain foreign laws. And as in the Gender Recognition Act, the control mechanism is the Secretary of State's power to delete foreign statuses from the scheduled list. My third example is from the Gender Recognition Act. As I showed you, it's an essential requirement of changes of gender under English law that the individual's been diagnosed with gender dysphoria or, through the alternative route, undergone gender reassignment surgery, and that the case is subject to independent medical and judicial scrutiny. The concept of changing gender for other reasons or through self-identification is antithetical to the English law system. Such a change could no more constitute a change of gender under English law than a change to non-binary gender. but the Act allows for the recognition of changes of gender that have occurred under foreign law, where there's no diagnosis, no surgery, no medical evidence, no judicial scrutiny. And as I've already made the submission, Ms. Thompson notes a number of countries listed in the 2011 order that operated a system of self-identification. My fourth example concerns the recognition of foreign marriages under the Gender Recognition Act. For this, could we please look at tab 1, page 32. Section 11, capital A, addresses the impact of a gender recognition certificate on certain foreign marriages. The section refers to protected marriages. I don't think we need to turn it up, but section 25 defines a protected marriage as a marriage under the law of any country other than Scotland. Subsection 4 of section 11A, bottom of the page, a foreign marriage is a marriage under the law of a country or territory outside the UK. Then overleaf, top of the page, proper law is defined as the law of the country in which the marriage was entered into. And then if we could please turn back to subsection 3. This provides that if the marriage is a foreign marriage, then A, the continuity of the marriage continues, even if that would be impossible under the foreign law, and B, the law governing the marriage remains the foreign law rather than English law. So, for example, suppose that a marriage between a man and woman was entered into in Saudi Arabia. The woman then changes gender in the UK under the section 11A route to become a man. Saudi law remains the law applicable to the marriage. Saudi Arabian law doesn't permit same-sex marriage, and yet the effect of subsection 3 is the UK will treat the Saudi marriage that's now between two men as being valid in the UK. And so in my submission, the Gender Recognition Act not only provides for the recognition of statuses that can't arise under English law, it also provides for the recognition of statuses that can't arise under applicable foreign law in this limited way. I then take my fifth and final example, if I may, from EU law. A person's status, such as gender or marriage, is a matter that falls within the competence of member states rather than EU law. So, for example, there's no obligation under EU law for a state to recognise same-sex marriage. But, as we explained in our skeleton argument, the right to free movement may require member states to recognise a status that's been granted by another state. So, for example, even if a member state doesn't recognise same-sex marriage under its domestic law, it must recognise a same-sex marriage contracted under the law of another state, if necessary to avoid impairing free movement. Now, the only point I make about that in this context is that the requirements for the state to recognise the foreign law status doesn't undermine its domestic law system. And on that point, could I please ask the court to turn up tab 53? This is the European Court's judgment in the case of Coleman. And if we could look, please, at page 1358. If the court would please read paragraph 45. Now, those 5 examples illustrate my first submission on consequences. That Parliament can, and sometimes does, recognise alien foreign law statuses without threatening the coherence of the domestic law system. Just as polygamous marriages are recognised without threatening the English law system of monogamous marriage, the recognition of gender as defined by foreign law, we say, doesn't threaten the English law concept of gender. Now, my second submission on consequences is that we accept that insofar as it makes distinctions based on gender, all legislation in the UK is based on male or female gender. If a person changes gender under the Gender Recognition Act from male to female or female to male, then the change can be accommodated into the framework, straightforwardly, subject to the exceptions contained in the Act or contained elsewhere. What would the position be in respect of a non-binary certificate obtained pursuant to section 1, subsection 2b on our interpretation? Well, section 9, subsection 1 that we've looked at, the individual's gender would become non-binary for all purposes, but that's qualified by section 9, subsection 3. It's subject to provision made by any other enactment or subordinate legislation. Now, if legislation, such as benefits legislation, requires a person to be either male or female, then it may be impossible to accommodate non-binary gender into that legislative framework. For example, take legislation that confers an entitlement to a pension at the age of 60 for women and at the age of 65 for men. And the applicant has a certificate saying they're non-binary. Whether an individual with intersex or non-binary gender could fit into that scheme would turn, in my submission, on the proper interpretation of the Benefits Act. And it might be that in an intersex or non-binary case, the Benefits Act would be interpreted so that chromosomal tests would be applied to determine how to fit the individual into its requirement for male or female status.
does section 9 subsection 3 mean what you're submitting? When I'm looking at it at first blush, it might mean section 9.1 says where a full, sorry, I'll let you get there. Section 9.1, where a full gender recognition certificate is issued to a person, the person's gender becomes, for all purposes, the acquired gender. But then 3, subsection 1 is subject to provision made by this Act or any other enactment or any subordinate legislation that suggests an express exclusion of section 9, subsection 1, rather than simply, I think what you're submitting is that if you've got an Act which on the face of it is difficult for a non-binary gender to be accommodated, you don't have to recognise the non-binary gender. You do the best you can with the wording of the Act, if I understood you.
Well, there'll be two possible approaches in my submission. One could either say, well, if you've got a non-binary certificate and the Act provides for male or female, you simply don't fall within the Act at all. The Act is simply inapplicable to you.
Yeah.
The better interpretation in my submission would be likely to be, we're talking hypothetically because it depends on the proper interpretation of the Act in question, but it may very well be that the proper interpretation of an Act which says you have to be male or female to qualify the provisions of this Act would be read as providing that the non-binary person, notwithstanding the certificate, could come within the Act because they could, for the purposes of that Act, be described as male or female, for example, applying a chromosomal test.
Right. I just wonder whether that's putting too much weight on subsection 3. But there we are.
I'm told that this is the subject, or was the subject of debate before the Supreme Court in the For Women in Scotland
Was it?
case. So we may yet get an answer.
Wiser heads than mine.
But the court, I hope, has my submission on.
Yes.
Did this court say anything on this question in McConnell? Don't answer that now, but...
In McConnell?
Yeah.
Not that I can recall, but I'll check and answer more fully if I may in due course. On this point, could I please ask the court to look at the case of Bellinger, which is at tab 32. Now, I'm sorry that you haven't got the reported case. I can hand up a reported copy.
Yeah.
The court wants.
Got it, actually.
We have got it from other means.
I'm grateful.
You're going to use the transcript.
Well, I was just going to refer to 2 paragraphs, so we can do it either way.
Yeah.
This is the case, of course, in which the House of Lords held that the absence of a domestic system for recognising changes of gender so as to allow trans men or women to marry a member of the opposite sex was a breach of the positive obligation under Article 8 ECHR. But the bit that I want to show the court, if I may, is paragraphs 5 and 6 of Lord Nichols's judgment.
Yes.
Yes.
So, nature doesn't draw straight lines, but if the parliamentary draftsman draws straight lines, then an individual will have to be fitted into the statutory categories as best they can be.
And the factors are that are referred to as set out in paragraph 5. So it posits that there is a means of determining it.
Yes. Well, the
For intersex, at any rate.
yes. But similarly, I mean, even chromosomes don't always align to XXXY. But in a case where chromosomes do align to chromosomal gender, and the legislation requires the person to be male or female, then it might be possible, it will depend on the act in question, but it might be possible to construe the legislation as requiring male or female gender according to chromosomal sex. Depends what the Act says. And in my submission, Section 9 of the Gender Recognition Act doesn't require the impossible. It doesn't require the legislation that's predicated on binary gender to be read in a way that accommodates non-binary gender. That, in my submission, is the proper interpretation of subsection 3. Now, I accept that this approach of working out how to integrate a person with non-binary gender into binary systems, into binary legislation, imposes some burden. But we don't accept that it's a significant burden because there's no evidence that countries like Germany, Australia, the US or Canada have had difficulty recognising non-binary gender in a generally binary world. But whatever the nature of the burden, in my submission it's one that already exists. It wouldn't be created by the non-binary certificate. For example, if a person registered as intersex at birth in Germany applies for welfare benefits in the UK, then UK benefits legislation will need to be interpreted to work out if and how the person should be treated under that legislation. The appellant's current position is that their registered gender is non-binary, and their identity documents, birth certificates and passports, record that non-binary gender. Any public body applying UK legislation already has to work out how to fit that gender into the binary legislative framework.
But they do that by coming to some form of determination, which is of a binary nature.
Yes.
Determining whether they are male or female. But what, as I understand it, you're hoping to achieve by recognition under the UK gender recognition system of non-binary is a freestanding status recognised in UK law, and isn't the consequence of that the UK agencies will themselves have to expand the categories that they recognise from simply being M and F to including X or whatever further categories may be added?
In my submission, no. I've sought to answer the question in relation to legislation. The answer in a case where the public body's powers and duties are defined by legislation will be answered by the proper interpretation of the legislation. And it may be that a non-binary person will have to be fitted into the category of male or female to make sense of the legislation in their case. It might be that if they can't be fitted at all, then they simply can't take advantage of the legislation.
And so the issuing of certificate recognising non-binary, you say doesn't necessarily solve the difficulty the benefits agency would have or anyone else would have because of the nature of the benefit or whatever it is they're dealing with requires a binary decision. So it would be exactly the same position as it is now.
Exactly.
At that end of the process.
Yes, my submission is that if legislation requires binary gender, then a non-binary certificate won't make the blindest bit of difference.
I can see that.
So in a practical sense, where will having such a certificate make a difference? Because presumably this case is brought because it's felt that there is some advantage
Yes.
in having such a certificate.
Can I, if I may, park that question for a moment? I'm going to come on to deal with it, but I'm going to more comprehensively say why it doesn't make any difference to public bodies. But then I anticipated the court.
Difference to your client.
Yeah, exactly. I was going to I anticipated the question, well, why are you here? What's the point of the certificate? And I'm going to explain that, including by reference to the psychological impact and my client's sense of dignity. Now, I've so far dealt with alien foreign law statuses don't threaten the coherence of the domestic system. I've dealt with my points on the construction of binary legislation if there's a non-binary certificate. My third point is that we also accept that quite apart from services provided pursuant to statute, public services are often based on binary gender. For example, computer systems may only permit male or female gender to be recorded. Certain services, such as prisons and hospital wards, differentiate based on male or female gender as a matter of administrative policy. Others, like domestic abuse refuges, are only available to women. Now, we accept that it would or might well be costly and burdensome to reorganise administrative systems and public services to make different provision for non-binary gender. But my submission is that issuing a non-binary certificate wouldn't impose any duty to reorganise any administrative system or provide public services differently. And can I explain why? The Gender Recognition Act doesn't impose any duty to treat a person with a non-binary certificate in accordance with their non-binary gender. And there is no other legislative duty to treat a person with a non-binary certificate in accordance with their registered gender. One can't claim sex discrimination based on non-binary gender because of the definition of sex that I showed the court in the Equality Act. Now, I note that gender reassignment is a protected characteristic, but a non-binary person like the appellant has that characteristic whether or not they're granted a gender recognition certificate. And so a non-binary certificate wouldn't impose any additional obligations on public service providers under the Equality Act. Now, the common law would require a public authority to make adjustments to accommodate a non-binary person if it was irrational not to do so. And Article 14 ECHR might require a public authority to make adjustments for a non-binary person if it was disproportionate not to do so. But it's inherent in the rationality and proportionality standards that no undue burden will be placed on public authorities. For example, providing that it's rational and proportionate to do so, there would be nothing unlawful about recording the non-binary individual's gender on HMRC's computer system as male or female.
Do you say this is an issue which has to be looked at on a case-by-case basis? Or should one look at it in terms of the consequences more broadly?
Well, the question
Because
of...
you're using examples of where it wouldn't be, but the answer may be different if you look at the overall effect.
Well, I'm attempting to deal with this in a general way, in the sense of looking at what the applicable test would be. I accept that in applying the test of rationality and proportionality, there may be cases in which adjustments would need to be made. But the submission that I'm making is that wherever an obligation were imposed pursuant to the rationality or proportionality standards, it necessarily wouldn't be an undue burden on the public body.
But my lady's right, isn't she, with respect that the testing out of that, what is an undue burden, what is irrational, what would have to be taken topic by topic, case by case.
Well, it would, but one can look at it on at a theoretical level by considering the nature of the rationality and proportionality standards, which by their nature don't impose undue burdens. That's the submission I was attempting to make.
It would only apply in the sharp end of the cases where the issues are stark.
Yes, at the moment I'm attempting to address the argument that's made against me, which is that my interpretation of the Act would impose undue burdens on the state, which would be an absurd consequence, which means that my interpretation of the Act can't be right. My submission is, no, it wouldn't have any undue impact because the obligations that might be imposed pursuant to the rationality or proportionality standards necessarily don't impose undue impacts. And so I've given the example of the HMRC computer system. Similarly, providing that it's rational and proportionate, there'd be nothing unlawful about treating a non-binary prisoner as a woman or a man for the purposes of prisons policy.
So do you say that's to be read into, as it were, I'm trying to work out what you are saying for all purposes means in the context of Section 9.1 and what the ambit of that is, what's within and without it.
What would be happening in the case of a prison which treats a non-binary prisoner as male or female would be that the prison would be saying, we recognise that you are non-binary, but our policy is predicated on male and female gender, and we have to fit you into one of those categories. There is no breach of statutory duty in my submission in doing so. The individual would have to complain that allocating them in that way would be irrational or disproportionate. Now, again, it may be necessary for a public body to think about whether they can and should make accommodations for the non-binary person. And the requirement to think imposes some burden in itself. But the requirement to think about a person's non-binary gender, again, already arises if their birth certificate and passport record them to be non-binary, as in the appellant's case. A certificate doesn't add to that burden. And so, for example, when dealing with the appellant's biometric residence permit application...
Well, is that right? Then, because of Section 9.1, I mean, there's a duty in Section 9.1, or it says that the state is required, where a full gender recognition certificate is issued to a person, the person's gender becomes, for all purposes, the acquired gender, and so on.
Well, I respectfully disagree that it imposes a duty. It provides that, as a matter of law, the person's gender becomes non-binary. Whether or not that imposes a duty on a public service provider to act in a particular way is a separate question. I was just going to give an example of how the obligation to think already arises regardless of a non-binary certificate. When dealing with the appellant's biometric residence permit application, the Home Office had to work out how to address the appellant's non-binary passport. And the DVLA had to grapple with the appellant's non-binary gender when issuing a provisional driving licence. In both cases, as it happened, they assigned a female gender. The reference to that is the supplementary bundle, page 9, paragraphs 26 and 27.
But I thought that that was part of the hurt which the appellant says that they have experienced. And I can understand that.
I accept that, my lord.
To be called female when that was not even your gender at birth, let alone your gender under the law of California. So isn't that just going to mean that the issue will have to be decided on another day in a different forum?
The submissions that I'm advancing don't solve that problem. They don't give the appellant that part of the remedy that they seek. But they do help, and I'm going to explain why in a moment. I accept that to go further, one may need to establish a positive obligation under Article 8 to recognise non-binary gender more generally, and for the domestic law system to recognise non-binary gender. But in the light of the way that it was addressed by the Supreme Court in Ellen Kane, and in light of that submission's not open to me, and so I don't advance it. My submission is a very modest one by comparison. And the consequence of that is that it doesn't give the appellant everything that they seek. But for reasons I'm going to advance in a moment, it does advance things a material step. Now, speaking of Ellen Kane, this case, in terms of legal and administrative consequences, is quite unlike that case. There, the appellant sought to compel the Passport Office to issue non-binary UK passports. That raised security concerns, it would have been expensive, it would have been imposed an administrative burden. But none of those considerations in my submission apply here, because issuing a certificate to match the appellant's US birth certificate and passport wouldn't compel any consequential administrative action, unless it would be irrational or disproportionate not to act. And I note that it wouldn't even be necessary to amend the gender recognition panel's computer system to generate a non-binary certificate, because as the President, Ms. Gray, explains, the panel can already issue certificates recording gender as not specified, and the appellant has explained that they would be content with a not specified certificate, as long as it's understood that that covers the position of non-binary people. And finally, on the question of consequences, of course, if the Minister considers that issuing non-binary certificates in foreign recognition cases would nevertheless have undesirable consequences, then she can always delete a country recognising non-binary gender from the approved territory's order. Now, having put it off, could I address my Lord's question about if the legal consequences are so minimal, why does the appellant want a certificate? 3 points, if I may. First, the Minister asserts that in the UK, the appellant is legally a man for all purposes. And we don't accept that because the appellant's only registered gender is non-binary. But it's very hurtful to be misgendered in that way. For the UK formally to recognise and respect the appellant's gender would be of great value psychologically, even if it's not always possible for public bodies to make accommodations for that gender. And the expert evidence is that the appellant suffers clinically significant distress as a result of not having their gender formally recognised by the UK. Could I perhaps just give the court the references to that expert evidence? It's Dr. Juber's report, supplementary bundle, page 16, paragraph 2.1, and page 29, paragraph 62. And those are both passages that the High Court admitted into evidence. Could I also please ask you to note the judicial observations to the same effect that my Lord cited in the McConnell judgment? This is at tab 41. And at page 862, my Lord cited Baroness Hale's judgment in the case of C. If I could ask the court please to read the extract from the case of C from 3 lines below letter D, beginning "those of us who, whatever our occasional frustrations."
Yes.
So even if some public bodies would continue to record the appellant's gender in different ways, even if it's not possible to accommodate the non-binary gender in many situations, it would make a meaningful difference psychologically and in terms of the appellant's dignity for the state formally to recognise their non-binary gender. So that's the first point. My second point is that the appellant is a cybersecurity expert who's in the UK on a Tier 1 global talent visa. The work requires security vetting, and that includes making declarations about identity, including gender. And the appellant is anxious to avoid being accused of providing false information. And the evidence on that, if I might just give you the reference, is supplementary bundle, page 10, paragraph 30. And then my third and final point on this is that even though a non-binary certificate won't, in my submission, impose any significant legal obligations on public or private bodies, it is liable to foster respect and consideration. For example, Ryan's employer has decided to recognise and record their non-binary gender, that's set out in their witness statement. No doubt having a US non-binary birth certificate and passport goes a long way to facilitating such consideration. Having a UK non-binary gender certificate is liable to help further. So for all of those reasons, we say that our approach to the interpretation of the Act has utility and doesn't result in absurdity. Could I then please turn to my third topic, which is the purpose of the foreign recognition provisions. We accept that the spur for the Gender Recognition Act was the judgments in Goodwin and Bellinger, and the problem of the lack of official recognition for male to female and female to male transgender persons. And in Bellinger, the House of Lords held that what was required was a set of objective criteria by which gender reassignment could be assessed. That's paragraph 42, Bellinger. But Goodwin and Bellinger didn't say anything about recognising changes of gender that have taken place under the law of a foreign state. And it would have been consistent with those judgments to require all persons to satisfy the domestic criteria for changes of gender, or at least require those who change gender overseas to demonstrate that the foreign law criteria were substantially similar to the objective UK criteria. But as I've sought to show the court, the foreign recognition framework in the Act allows for the recognition of changes of gender under foreign law that's very different from the objective UK criteria. For example, gender change without medical evidence, gender change during childhood, etc. And in providing for the recognition of gender acquired under foreign law that might not resemble changes of gender under UK law, Parliament went significantly further, in my submission, than addressing the Bellinger problem. Why did it do that? And in my submission, the answer is the same as the reasons for recognising alien foreign statuses in other contexts. That is comity, in the sense of, so far as possible, respecting the laws of other countries and the rights of citizens derived under those laws.
I suppose another thing that flows from such comity is stability in legal relationships.
Yes.
Because otherwise, if for example, people cross frontiers, and they may cross frontiers because this country needs them, because, for example, they're a highly skilled migrant. But if you didn't have your foreign marriage recognised, for example, even though it's polygamous, etc., there can be difficulties. So I think that may be one of the rationales behind the comity principle.
Yes, well, I respectfully agree. And that informs the approach that the European Court has taken in respect of the EU law approach to statuses. Of course, it's not. The Act doesn't provide for a perfect international framework because it's subject to the foreign territory being included in the order. But my Lord has put a proposition that I respectfully agree with, insofar as the Act is providing foreign recognition. Now, we know that the Supreme Court's judgment in Ellen Kane, we know it was set out in that judgment that New Zealand has permitted non-binary gender markers since, or at least was contemplating it, in 2005. So it's possible that when enacting the Gender Recognition Act, Parliament was alive to the possibility of a gender being acquired under foreign law other than male and female. But in my submission, it doesn't matter whether or not Parliament contemplated that. Because what Parliament did was to create a structure for the domestic recognition of statuses created under foreign law, even if foreign law criteria were unlike the UK criteria. And the genus of facts for which Parliament was legislating was a change of gender under foreign law, rather than certain categories of change of gender under foreign law. And the change of gender in an approved territory to non-binary gender, in my submission, comes within that genus of facts. Now, on that point, could I perhaps ask the court to look at the case of Quinterville, tab 31. And if we could start, please, at page 490. At letter F, Lord Bingham set out section 1, subsection 1 of the Human Fertilisation and Embryology Act 1990, which one can see defined embryo to mean a live human embryo where fertilisation was complete. And the case concerned embryos created through a form of cloning. That kind of embryo didn't exist when Parliament enacted the 1990 Act, and it was held that that form of embryo didn't involve fertilisation, as referred to by section 1, subsection 1. And the question was, did that form of embryo nevertheless fall within the scope of section 1, subsection 1? The House of Lords held that one has to construe statutes as always speaking, and that doesn't mean asking what would Parliament have done if confronted with these facts. Rather, where new facts have arisen since the enactment of legislation, the question is whether they're covered by the Act, which turns on whether they fall within the same genus of facts that are those covered by the legislation. And the House of Lords held that Lord Wilberforce's statement on the point in the Royal College of Nursing case was authoritative. And if I could please show the court that. It's page 493. And the court will see at the top of the page the citation from Lord Wilberforce's judgment. If you could please read that. And then the well-known example is given at page 492, paragraph 9. If an act covers dogs, then it covers animals that are recognised as dogs now, even if they wouldn't have been recognised as dogs when the act was passed. Similarly, the House of Lords held that a cloned embryo is within the same genus of facts as an embryo formed through in vitro fertilisation, even though such a thing didn't exist in 1990. So we say that even if Parliament didn't foresee the possibility of non-binary gender under foreign law in 2004, it's within the same genus of facts. It's a change of gender provided for by the law of an approved country or territory. In my submission, the genus covered by section 1, subsection 2b of the Gender Recognition Act is the foreign law definition of change of gender and not the domestic law definition of change of gender. And it follows that as foreign law expands or contracts the nature and scope of changes of gender, so will the facts falling within the genus. That then takes me to my fourth topic, facts of the appellant's case, and all that I propose to show you is how the panel interpreted section 1 subsection 2b of the Act. This is in the core bundle, tab 8, page 95. This is a letter from the President of the panel to the appellant. If the court could please read the paragraph beginning, "The situation is that." And we say that the analysis in that paragraph is correct. The only remaining question was, what was the appellant's acquired gender for the purposes of the certificate? And we say that's spelt out by section 1, subsection 2b, namely the gender to which the person changed under Californian law. Unless the court has any questions at this stage, those are my submissions on the interpretation of the Act. That then takes me to Article 14, on which I'm going to be much quicker. We only get...
Even quicker.
We only get to Article 14 if the court concludes that the words of Section 1, subsection 2b, the gender to which the person has changed under the law of the country or territory concerned, mean the male or female gender to which the person has changed under the law of the country or territory concerned. Now, as I sought to show you, even on that interpretation of the Act, it permits the recognition of foreign law changes of gender that could never be obtained under domestic law. For example, acquired gender through self-determination in the absence of gender dysphoria. And the difference in treatment we rely on is between that kind of foreign law change of gender, a change to male or female gender that would be impossible under UK law, and another kind of foreign law change of gender that would be equally impossible under UK law, but involves non-binary gender. In both cases, there would be no impact on the domestic law approach to changes of gender. The domestic law principle that changes can only be to male or female would be no more undermined than the domestic law principle that changes must be based on objective, medically diagnosed condition. case of Ellen Kane was different. That was a comparison between genders that are recognised in domestic law, male and female, and a gender that isn't recognised in domestic law, non-binary. As I say, here we're concerned with a comparison between two changes of gender, neither of which could be acquired under domestic law.
Is that right? It may be, maybe Sir James won't accept this, but let's assume for the moment that you're right, that the provisions of the GRA on foreign certificates do apply where, as in California, as I understand it, you have a self-identification system. That's the means by which you get there, but the destination to which you arrive is still, on Sir James's submission, either the acquired gender is male or the acquired gender is female.
Yes.
So that one can see readily fits into the framework of the GRA as Sir James contends it is otherwise. But what you're asking for here is a different kind of comparison where the destination is different. It's not just the means by which you get to the same destination.
Well, the thing, the benefit on my characterisation is a certificate. And the comparison is between the criteria for obtaining that certificate. Now, if the position was you can only get the certificate, the benefit, if you satisfy the domestic law criteria, then my argument would collapse into the positive Article 8 obligation argument that the Ellen Kane argument collapsed into. But the comparison that I'm relying on here is different. It's a comparison between one person who can't satisfy the domestic route with another person who can't satisfy the domestic route. The destination point, the certificate, the benefit is the same. The criteria for the purposes of comparison are different. The only difference, the ground on which the person is being treated differently within the wording of Article 14, is gender, as defined by the foreign law. So I put it this way, that having chosen to confer a benefit, a certificate, on one person who couldn't change gender in the UK, the example being a person who obtained male gender through Californian self-ID, what's the justification for then denying that benefit to another person who couldn't change gender under UK processes? In this case, a person who obtained non-binary gender under Californian law.
Now, strictly speaking, I think within Article 14 language, what are you relying on? Is it the concept of other status? Is that the ground on which there's discrimination taking place?
Well, I would seek to persuade the court that it constitutes sex.
Ah, right.
But if I'm wrong about that, then I rely on other status. At this, I'll come on to that if I may in a moment. At this stage, I'm seeking to draw a distinction between the Article 14 analysis in this case and the Article 14 analysis in Ellen Kane. Because our Article 14 claim is fundamentally different from an Article 8 positive obligation case. Because we're not arguing that domestic law should allow individuals to acquire non-binary gender, or that there should be across-the-board recognition for non-binary gender. And so we respectfully say that the High Court was wrong to say that the absence of a positive Article 8 claim was relevant to the Article 14 assessment. That's what they said at paragraph 129. turning then to the rubric of Article 14, the High Court found that the requirements of ambit, status, and analogous situation were satisfied, and there's no respondent's notice. The status is the appellant's particular sex or gender as defined by Californian law. In addition, the court will have seen that the appellant's legal sex conforms to their diagnosed psychological condition and to their body following surgery. And whether one can place that within the word sex as it's used in Article 14, or whether one has to deal with that under the concept of other status, in my submission doesn't much matter, because differences based on immutable characteristics, like sex, require very weighty reasons. And the High Court was prepared to assume that very weighty reasons were needed to justify the difference in treatment in this case, and in my submission they were right to do so. In relation to the proportionality balance, what are the factors to be placed on each side of the scales? On the side of the scales concerning the state, the interests of the state, the Minister relies on the need for an administratively coherent system and administrative difficulties if non-binary gender were recognised. Now, I've already made my submissions on that when we looked at the consequences of our interpretation of the Gender Recognition Act. Recognising an alien foreign gender in this context no more undermines the coherence of the UK's binary gender system than recognising the alien foreign concept of self-identified gender undermines the UK's objective system based on medical evidence, and no more than recognising polygamous marriage undermines the UK's monogamous system of marriage. The court has my submissions on that. And for the reasons that I've also given already, recognising a foreign non-binary status, we say, won't undermine the operation of legislation that's based on male or female gender, and it won't impose any additional public law duties, save to act rationally, proportionately, and that can't be said to impose an undue burden on the state. And I've also made my submissions already on the other side of the scales, the impact on the appellant, when I explained why we say that a gender recognition certificate would be of value. Recognition, respect, and avoiding criminal liability for misstating identity. And in those circumstances, in my submission, the minimal impacts on the interests of the state don't constitute very weighty reasons that clearly outweigh the adverse impact on the individual. But I then please say a word about Human Rights Act remedy. Under Section 3 of the Human Rights Act, the question is whether it's possible to read gender under foreign law as meaning gender as defined by foreign law, no more, no less, without going against the grain of the legislation. Or as it was described in the case of Guyton, without turning black into white, or without turning the legislative scheme inside out. Now, I accept that binary gender is part of the grain of the domestic law system, but in my submission it isn't part of the grain of section 1 subsection 2b. And reading 1(2)b as referring to foreign law without limitation doesn't impinge on the domestic law system, doesn't go against the grain of the domestic law system. But if the court agrees with us on that, and the Act can't be read compatibly with Article 14, then we respectfully seek a declaration of incompatibility under Section 4. Those were my submissions on Article 14, unless there are any questions.
Well, if we reach that last stage of the analysis, then would there be any conceptual reason to distinguish the foreign regime from the domestic regime? In other words, would a declaration of incompatibility in practice be tantamount to saying that the domestic regime is also incompatible? Because let's say that somebody like this appellant is entitled to that declaration. Isn't the next case going to be the domestic citizen who says, I'm being discriminated on grounds of nationality because I'm not entitled to a non-binary certificate?
Whether or not there would be proportionate justification for treating the domestic person differently from the foreign person would arise on that case.
Right, so wait until that case arises.
Wait until that case. But the scheme is predicated on differences in treatments between people who have acquired gender under foreign law and people who acquire gender under the UK system. And if the minister's case is well founded, and I don't attack this part of the case, the minister's case that the coherence of the domestic law system is of paramount importance, then there might well be a good justification defence to the Article 14 claim that my lord was suggesting. To repeat the point I've made, we are solely comparing two categories of foreign person, neither of whom can satisfy the domestic criteria.
Thank you.
Unless I can assist further, those are my submissions.
Thank you.
Thank you very much. Well, it's now, I think, nearly 1 o'clock, so I think we'll start afresh at 2 o'clock. Very much. All rise.
All rise.